happen from time to time. You should also. After that, unless I'm not sure how he's gonna do it. Sometimes he'll have them go with it at the time. It's not entirely stable.
All rise. Superior Court of Fulton County Manager, Circuit in a session.
Thank you all. Please be seated. All right. Good morning, everybody. We are here on 25CV002691 RGP Bowman Solar LLC as the petitioner versus Georgia Public Service Commission as respondent with an intervener of the Georgia Power Company. And so first, let's have appearances for the record, starting with the petitioner.
Morning, Judge. Newton Galloway and David Penland on behalf of RGP Bowman Solar. We're joined also by Mr. Anderson, who's the state.
All right. Welcome, Mr. Galloway. And on behalf of the commission.
Good morning, Your Honor. Samuel Smith and Jeff Stump. Jeffrey Stump.
Stump.
Yeah.
Okay. Welcome. And on behalf of Georgia Power.
Yes, good morning, Your Honor. Tom Riley. I'm here with my colleague Dan Pritchard and our summer associate Grace Regitz and our client Elizabeth Helmer with the legal department of Georgia Power Company.
All right. Welcome all. And the parties come to an agreement on takedown.
Yeah.
Yes, Your Honor. Ms. Hawkins is here. All the parties have agreed to share in the takedown. I assume we divide it by 3. Or
Certainly, yes.
All right. All heads nodding in agreement. Then we've covered that. So we move in to the reason we're here today. And so we've got motions to dismiss filed by both the respondent and intervener. We've got responses, we've got replies, all sorts of briefing, and I've had a chance to review some of that, but there's a lot of issues going on here, so plenty to dive into. And with that, I would say we kick it off and let I don't know if the respondent and intervener should agree who's going to argue, but I'll let y'all get started.
Thank you, Your Honor.
This is just a joint argument on behalf of that side of the V.
So both of us, so the AG's office appearing on behalf of the Public Service Commission and Georgia Power will both speak.
Okay.
We'll follow up and endeavor to avoid duplication, Your Honor.
All right. Sounds good.
Judge,
Take it away.
Is
Yes,
this,
sir.
does the court hold a time limit to the arguments, or is this?
I had not, I mean, I've got the mornings cleared, and we could probably spend days talking about all of this. So I haven't set one, but I will try to just move things
I don't
along.
anticipate taking a huge amount.
Okay. I'll ask the parties to endeavor to be efficient. So
Mr. Smith, come to the podium.
understood. Mr. Smith, take it away.
Thank you. May it please the court, my name is Samuel Smith, appearing on behalf of the Respondent Public Service Commission. The Public Service Commission, or the Commission, comes before this court to ask this court to grant a motion to dismiss the petition for judicial review in its entirety. On motion to dismiss, all pleadings are construed in favor of the party who filed them, and all doubts regarding such pleadings must be resolved in the filing party's favor. And Your Honor, there was an additional motion before you that was earlier this week. Bowman filed an application for leave to present additional evidence. The commission asked that this court not decide on the application until it considers our motion to dismiss. And should our motion to dismiss be denied, that the commission be given the opportunity to respond to that application. I've not had the opportunity to discuss the application with our client, and having reviewed it, it appears to go to the merits of this case.
It goes to the merits.
Marriage.
Right.
That's
Okay.
not before the court today, and we will cooperate with the commission's counsel and whatever to allow the time to respond. We were under a deadline under 50-13-19F that said, if you're going to present or ask to present evidence, you've got to get it in before the hearing. So.
Well, and there might be multiple hearings, right? If we get to a merits
And-
hearing.
And that was the source of trying to get it in, because There may or may not be multiple hearings on this. So
Understood. And would you say, Mr. Galloway, that, and apologies, I take things out of order all the time. So would you say, Mr. Galloway, that the evidence contained in that is really confined to the merits and not so much as to this issue of mootness that is raised? All right. Okay, Mr. Smith.
Thank you, Your Honor. So to boil this case down, because this is a complicated case with a lot of moving parts. So Bowman signed a contract with Georgia Power, and the commission cannot change that Bowman signed that contract. Bowman is asking for an evidentiary hearing, but granting an evidentiary hearing would not endow the commission with the authority to rewrite an executed contract. So the underlying issues here are moot. We simply cannot grant the relief sought here. Additionally, facilities such as Bowman go through what's called the interconnection queue. Bowman's position in the queue was up, and at that point, it had the opportunity to sign a contract and move on with its project, or not to continue with the project and be removed from the queue. No evidentiary hearing will change the reality that Bowman is out of the queue, and so the petition is moot on that ground as well.
So I want to start there. And so, I don't know the practical, I know they're alluded to in the briefing, but the timeframes and the practical realities of the interconnected analysis. But under the mootness doctrine, there is a situation where something can be capable of evading review. And so these are very short timelines on when someone's expected to sign these contracts. If the commission has taken the position that a hearing isn't required to consider the reasonableness of these costs, and it does end up being that it qualifies as a connected case and the petitioner had a right to such a hearing, how would this ever get to the point of judicial review with such tight timelines? And if so, should mootness really be applied, even if they are outside of the queue and even if they can't get the complete remedy they want, they can still get an answer of whether this was a contested case and whether they had a right to a hearing?
Your Honor, so there are 2 points there. One, Bowman did receive review. This was actually a very extended process, and they went before the commission twice and were given the opportunity and did submit evidence, including their affidavits, present oral argument, and answer questions posed by the commission, and we can get into the dates a little bit farther.
They got review from the commission, but they're also entitled potentially to review from this court.
Yes,
That's what you're saying is moot, and what I'm saying is, isn't it just always going to evade review by the next level under the timeline you've proposed?
I apologize, Your Honor. And the second point being that they would have had the opportunity when they received the QFIA agreement to have petitioned this court for review and to have requested a stay at that point. Part of the issue in this case is that Bowman waited essentially until the last minute to file its stay, both with the commission, which denied that stay, and as we'll discuss a little bit more over the course of this, and has been discussed in our briefing, also waited 2 months to file for both review and stay with this court. That is why this is now sort of beyond review, because had they initially, that is, as soon as they received the QFIA, had they asked for a stay from this court immediately, then this process could have been frozen. The court would have had the power to grant that relief then. And so their failure to...
For the 28 or so days before that, the deadline came for them to sign it?
Yes, Your Honor.
They should have done an injunction or a TRO or
Yes,
motion for stay and hope that the court gets that on the radar.
Yes, Your Honor.
Okay. When you talk about the commission's review, this is kind of getting more to the merits of the stay motion. Is it your position that the commission did in fact do a analysis, not through a hearing, but did go into the merits of the reasonableness of the costs?
Yes, Your Honor. The commission staff reviewed both the evidence presented by Bowman and the evidence presented by Georgia Power and came to a conclusion that the costs at issue were justified. And in fact, those costs were incorporated in the commission's order. That's the November 26th, I believe, order that is attached as Exhibit A of Bowman's petition. And so those costs are actually outlined by the commission there.
And so it mentions it's completed a desk review of the costs. but it never comes right out and says, and we find that they were reasonable or anything along those lines. Is that just something we have to assume or read in between the lines?
Your Honor, the commission, that is true. The commission did not use the term reasonable. That said, essentially just wasn't on the commission's radar that the reasonableness would need to be addressed in those terms. That said, we are, among other things, we're bound by PURPA to make sure that these costs are revenue neutral, or excuse me, are neutral to ratepayers. So we are confined to what costs we can actually approve because they have to fit within the statutory scheme. And the finding was that these costs were justified. That is, these are costs that are required under the analysis that the commission conducted, relying on evidence presented by both parties, that these costs were the appropriate costs.
Is that just kind of by implication because it followed the applicable procedures? Because that really is the only kind of explicit finding I think the commission makes in the November letter, as best I could tell. But if you want to maybe direct me to something else.
Your Honor, I do not have anything else I can point you to
Okay.
at this moment for that.
All right.
No,
I know I threw you off track, but feel
no
free
problem.
to get
No
back
problem.
on board.
No problem, Your Honor. Thank you. And so to the question of the queue as well, Georgia Power is going to address the interconnection queue in their argument. As we just did, we can answer questions regarding it, but Georgia Power has greater familiarity with the technical process of a queue, which they administer with oversight from the commission. So Bowman asked that this court, in effect, remand this case to the commission and order the commission to conduct an evidentiary hearing concerning various costs that Bowman was required to pay under a contract between itself and Georgia Power, issued per commission order. Bowman brought suit for declaratory rulings concerning these costs before the commission below, as we've just been discussing, and asked for an evidentiary hearing on these issues. Both requests for declaratory ruling and the evidentiary hearing were denied by the commission as in the order that we've just cited, and Bowman petitioned for judicial review of this court. Because Bowman's underlying claims for declaratory ruling are moot, its petition before this court is moot, and this court must dismiss for lack of subject matter jurisdiction over a moot claim. And we've already gotten a little bit into procedural posture of this case, but it is, as we've been alluding to, it's complicated. So if we can run through a little bit, it might be helpful. So essentially, this is a contract dispute between Bowman and Georgia Power. Bowman desires to build a solar generation facility, which is referred to as a qualifying facility or a QF. This QF would be interconnected to the electrical grid by Georgia Power. As part of the interconnection process, Georgia Power notified Bowman of the network upgrade and interconnection cost that Bowman would have to pay as part of an agreement between Bowman and Georgia Power to interconnect the facility. And so this agreement is a qualifying facility interconnection agreement, or a QFIA, as we have already discussed. Now, Bowman balked at the cost outlined in the QFIA, and Bowman filed a petition for declaratory ruling with the commission, asking that the commission determine whether the interconnection costs were reasonable and for an evidentiary hearing on the same issue. Bowman presented its affidavit petition, and this is now somewhat duplicative, but it's still worth mentioning, submitted affidavits and answered questions asked by the commission at a November 14th, 2024 meeting of the Energy Committee. Georgia Power also presented on that date. On November 19th, 2024, the commission's administrative session reviewed the petition and evidence, so that's the desk review, and commission staff recommended denying the petition. The commission denied the request for an evidentiary hearing and declaratory ruling and issued an order modifying the QFIA in part, and I think it's the order that's currently in your hand, but and ordering a new QFIA be issued to Bowman. And so that's the petitioner's Exhibit A. And then per commission order, Bowman was required to execute the new QFIA within 10 days of receipt, provide notice to proceed on the next day, and then pay various amounts by cash or letter of credit to Georgia Power within 10 business days of providing that notice to proceed. Bowman executed the QFIA and issued its notice to proceed as required under the commission's order, but on the day the payment came due, instead of paying, Bowman filed a motion for stay with the commission. After another hearing of the Energy Committee on January 16th, 2025, the commission rejected that motion for stay, and Bowman did not provide payment. So there have been at that point, it was over 2 months after payment was due, Bowman filed its petition for judicial review and request for stay with this court.
And so as you alluded to earlier, your position would be if they had filed that motion for stay or for the petition the day before, let's say, payment was due and got a stay from the trial court. At that point, it's frozen, and then, but your arguments about how the queue works and how this estimate, I guess, is now out of date. Those are still going to be apply, but just not have any bearing because the stay was granted before the contract signature was due, even if that stay could stay in place for years, in essence.
It would, and Georgia Power would be better positioned to discuss the effects on the queue. There would be harm to Georgia Power if it would, and conceivably the state of Georgia, to the extent that it would cause possibly issues with utilities having to interact in the queue. But if this court made the finding that that stay was justified despite those costs, then yes, that would be, at this point, the commission's understanding that it would stay the same.
I mean, so the fact that it might be before or after that signing date may not be as material to the granting of the stay as it is you showing the harm from putting someone back in the front of the line by court order. Is that fair to say?
I believe so, Your Honor.
And so, this first like $76 million estimate, I think, was first given to them as a quote in like 2023,
I believe so.
but they didn't have to pay that until end of last year. So that's almost, a year and a half, 2 years. Why should we assume that after just 6 months have gone by, that's no longer the right rate?
So, Your Honor, and again, Georgia Power can also discuss this, but it is the commission's understanding that the grid is a dynamic process. As new entities come online, generators come on, generators go off, consumers come in. The costs that are estimated are a snapshot of that moment in time, and that they are really only, essentially, that they are only accurate at kind of the moment they've been issued, because that is the point of a queue. You're up. Those are costs that are relevant at that moment. And as new generators move along in the queue, what happens above you has a downstream effect as you move through. So although those costs were initially given sort of deeper in this process, they were confirmed, and I do believe they were slightly modified. In fact, they were modified at least in part. Some were changed to refundable network upgrades.
So is the way it works, Bowman has got their spot in line in 2023, and they've just been holding the number one spot until this all got figured out?
Your Honor, I'm not sure, to be honest. That Georgia Power would be better positioned to discuss sort of where they were. But they, and to slightly modify that answer, so they are evaluated, and then when they come up, when they reach that spot in the queue, that's when they need to sign. That's when the QFIA gets issued.
All right. Well, I guess the point I was ultimately trying to inquire here was recognizing that getting out of the queue comes with complications.
That's right.
It seems like it's not always going to be a immediate defect to providing relief necessarily, because 6 months has passed since that expiration, but before that same rate was held open for maybe a year and a half, 2 years. And assuming, that this is kind of going around your mootness arguments, but there could be a scenario where a court could impose as a remedy, get them back in the queue, maybe even have to reassess the rate and start this process all over again.
So it is the commission's understanding that these rates would have to be reassessed were that relief to be granted, and that it would take, to our understanding, about 6 months of continued study, of essentially renewed study, to determine what the cost would be at that point.
And so if that's an applicable, if that's a possibility, wouldn't that mean that there is still relief that they could obtain, which is a court order that says you've got it because you didn't get the hearing you were entitled to, or, for one of the other claims, now you've got to go give them a new quote and start over and go back to the commission and assess the reasonableness after hearing?
To the stay, yes, Your Honor. To the issue of rewriting the QFIA, no, because having executed that QFIA, the commission simply lacks the power to change the terms of that QFIA. And so that is separating out sort of kind of different elements of the mootness analysis. The stay, there could be a relief granted here by virtue of the stay. However, the relief that Bowman ultimately seeks, kind of what's probably more important to them, is the rewriting of the terms of that QFIA, which they did execute. The commission does not have the power to do that. So that relief would still be impossible.
Do you, and I know this hasn't been the subject of the motion to dismiss briefing, but do you have any initial position on whether this would qualify as a contested case, this issue, and if not, why not?
We do not, Your Honor. at this
Okay.
point.
Okay. All right. What else?
All right. So the commission's order required, as we've been discussing, that Bowman pay its various interconnection costs to Georgia Power by a certain date, and that failure to pay would result in Bowman's project being deemed withdrawn from the connection process. Let's see here. So, because the date for payment came and went without Bowman providing payment, by operation of law, Bowman's project was withdrawn from the interconnection process and its QFIA lapsed. Because Bowman no longer holds a current valid QFIA, Bowman is not in a position of uncertainty with regards to its rights under a QFIA. Bowman essentially has no rights under a QFIA. Therefore, Bowman has no rights that are fit for declaratory ruling. Because Bowman has no rights fit for declaratory ruling, the underlying claims before this court are moot, and the court lacks subject matter jurisdiction to hear these claims. So again, that goes to that there's a distinction here between the ability to grant relief by stay versus the ability to grant the kind of ultimate underlying relief that Bowman seeks.
And do you think that would apply to all of the kind of enumerations of error that there is? Because this isn't just the hearing and the reasonableness. They bring up it exceeded its authority. There's due process issues. Are all of those mooted by the signing of this contract and the time that has passed?
Because it would be impossible to grant the relief. Yes, Your Honor.
Okay.
Although we have not briefed all of the merits of this. And so kind of the role of the commission in all of this, the commission oversees the valuation of renewable energy generation resources, such as the interconnection cost in this case. Per Georgia statute, it has general regulatory authority over electric utilities in Georgia. It also has jurisdiction to implement the provisions of the Public Utilities Regulation Policy Act of 1978, which is referred to as PURPA. Under PURPA, the commission has reserved the right to determine the reasonableness of any state jurisdictional interconnection cost assigned to a QF through a QFIA. The commission, per statute and commission utility rule 515-2-1-.2, may grant a petition for declaratory ruling when the petitioner is uncertain or insecure with respect to its rights under law or order. Bowman originally brought its petition for declaratory rulings against the commission, which was the original party to this case, before this court on appeal. Bowman's ultimate goal in pursuing this litigation is to persuade the commission to hold an evidentiary hearing and find that the assessed interconnection costs are unreasonable and to modify the terms of QFIA favorably to Bowman. And so that kind of gets to one of Bowman's many contentions, which is that the commission basically should not be here right now, or I should not be making these arguments on behalf of the commission. The commission may raise the lack of subject matter jurisdiction at any time to the court, and its motion to dismiss is properly before this court. It is black letter law that any party to a proceeding may raise the lack of subject matter jurisdiction at any time in a proceeding. The issue is so fundamental to a court's lawful exercise of its powers that the court itself may raise the issue as sua sponte. Bowman has cited no law or authority for its contention that the commission may not exercise its rights in this proceeding. And here, the QFIA was approved by the commission, and its required payments followed the commission's November 26, 2024 order. And per that commission order, failure to make those required payments would result in Bowman being deemed withdrawn from the project. It is the commission's understanding of its own order that the effect of the order upon Bowman's failure to timely make payment was the automatic removal by operation of law of Bowman's project from the interconnection process and the lapse of that QFIA. And so also kind of getting finally to actual the mootness issue here. In his briefing, Bowman has simply failed to respond to the commission's argument that even asserting for the sake of argument that the QFIA is still valid, which the commission does strongly deny, this matter is not fit for declaratory ruling. Declaratory ruling is only appropriate when a party is uncertain or insecure with respect to his rights. That is per Commission Rule 515-2-1-.12, and as well as per cases citing Georgia's declaratory judgment statute, which is OCGA section 9-4-2. And so in a case before the Court of Appeals, it was held that wherever rights of the parties have already accrued and there are no circumstances showing any necessity for determination of the dispute to guide and protect the plaintiff from uncertainty and insecurity with regard to the propriety of some future act or conduct, which is properly incident to its alleged rights and which, if taken without reasonable direction, might reasonably jeopardize its interest, the plaintiff is not entitled to a declaratory ruling. Because here, Your Honor, Bowman's case hangs on the proposition that it has enforceable rights under the QFIA. Even if that position is true, such a proposition is fatal to its claims for declaratory judgment, because there is absolutely no uncertainty or insecurity here regarding Bowman's rights under the QFIA. The terms are spelled out. They were spelled out when they signed it. In our motion to dismiss, they were redacted in the attached QFIA, but they are spelled out in relevant part in the Commission's order, as well as in Georgia Power's briefing, which included an unredacted version of that QFIA. And those obligate petitioner to pay various sums certain under the QFIA. Bowman does not like those amounts and has essentially admitted in its briefing that it cannot pay those amounts. But not being happy about payment obligations is not the same as being uncertain or insecure in one's rights. Bowman knows exactly what its rights are under the QFIA, and the attempts to obtain declaratory rulings on payment terms as being unreasonable is not supported by the relevant rules or statutes, and that's even if its QFIA were valid. Petitioner cannot point to any Georgia law or rule of the Commission allowing the Commission to change the terms of an executed QFIA, and the Commission's position is that it does not have the power to amend the terms of an executed QFIA against the will of one of the parties. So simply put, Bowman is asking the Commission to create new law here. Because under the terms of the QFIA, Bowman's rights are fixed. There is no uncertainty. Bowman just does not like its certain future. Bowman is trying to travel under the language of a suit for declaratory ruling when the underlying issue is not one of declaratory judgment. It is an attempt at rewriting an executed contract under the guise of a declaratory ruling in a way favorable to the moving party.
So the initial motion they made to the commission that was ruled on, I take it from the order that most of it was for declaratory rulings, but the very last one was asking the commission to take evidence and issue a final decision. Does that take the form of a declaratory ruling, or is that just a procedural, we want a hearing, and they didn't get one? So does that take that specific claim outside the declaratory analysis?
Yes, Your Honor, that was a procedural claim as sort of pursuant to those claims for declaratory ruling.
So how do you contend that that procedural claim is defeated?
So essentially, there is no rule or law that obligates the commission to hold an evidentiary hearing. The commission does not hold evidentiary hearings on this. And
This is getting more to the merits, though,
That's
right?
true.
So how do you defeat a procedural claim on mootness here, if you think you can?
Your Honor, I am not sure beyond that the commission actually did give them 2 opportunities to present that evidence. They did not get exactly the form that they requested there, but they were allowed to present oral argument and their affidavits to the commission.
So in essence, are you saying that your motion cannot be granted and this is a partial motion to dismiss because that claim is going to survive your motion? I know I'm putting you on the spot here, so we can switch around. We can go back to the lineup if you want to think about it.
I'm where my voice heard. Well, Bowman has not brought that issue up at any point here. They've really, in their petition for judicial review, our understanding was that they were asking that this be remanded relating to the declaration, for an evidentiary hearing. But that evidentiary hearing is tied to and intimately related to those requests for declaratory ruling. Just taking an evidentiary hearing doesn't really get them anything. They want that evidentiary hearing in support of their motions for declaratory ruling. If there's no motions for declaratory ruling, then that essentially does moot the evidentiary hearing. There's simply no point to having it at that point.
Well, I guess they would say that perhaps we could still change their mind if we were allowed to put on the full production. And even if this isn't in the form of declaratory ruling, if there's a procedural defect, then that's error and should be righted.
So, Your Honor, it is not error because the commission's position is it's not error. There was a finding that the appropriate procedures were followed here. And so I guess that would be a new claim of error that is kind of now being presented for the first time. And that, again, even if they presented evidence, the commission it would not have the power to revise that execute QFIA. The commission has taken evidence. It revised the QFIA. It was issued to Bowman. Bowman executed it. Bowman agreed to it at that point. And so now trying to come back at really well past the 11th hour, that is not commission error to have allowed them to go through all this, and to deny them at this point is not commission error.
I mean, or perhaps it's essentially waived even if there was error because they signed the contract agreeing to the terms.
Yes, Your Honor.
All right. Anything else, Mr. Smith?
We can walk through the evidence before this court that the QFIA has lapsed and Bowman no longer has rights to defend, which is sort of the alternative argument that the QFIA is gone. We have discussed this a bit. So the commission's order does lay out those various sums certain, and it does lay out a defined timeline that Bowman understood. And so working through the relevant dates, the commission order is issued on November 26, 2024. On December 6, 2024, Bowman filed a motion for reconsideration. On December 9, 2024, Bowman executed the QFIA. And then December 10th, issued a notice to proceed. Payment came due on the 26th. At that point, instead of paying, filed its motion for stay. On January 28, 2025, the commission denied the motion for stay, as well as that request for reconsideration. Now, Bowman raised an argument that needed to go through a multi-step termination procedure that's outlined in the QFIA. However, here the order controls and it goes to the queue. There was no need to go through the termination process outlined at various points in the QFIA. The order's effect was automatic by operation of law and resulted in the lapse of the QFIA by virtue of Bowman's withdrawal from the queue. At that point, there was in effect a lapsed QFIA because Bowman was no longer in the interconnection process. And notably, Bowman's own briefing concedes that it understands that its QFIA will be voided and would be removed from the interconnection queue for failure to pay as required under the order. If you go way back into Bowman's original motion for stay with the commission, that stated on page 3 that absent action by the commission to stay its order, quote, the QFIA will be voided, the QF facility will be removed from the interconnection queue. So that was Bowman's understanding of the situation, that the effect of the earlier failure of a stay, which was denied, would be the lapse of its QFIA. And so, Your Honor, Bowman has also requested a stay. Obviously, we've just spoken to it a bit. We've spoken some to it now, but Bowman should also present first to outline its claim, because that is a separate motion that was sort of included in that petition for judicial review. If the court would like us to speak further to it now, we may. But that's sort of.
You're referring to the application for new evidence?
I apologize, Your Honor. So Bowman's original petition for judicial review was styled something to the effect of petition for judicial review and request for stay.
Oh, I see.
And so it kind of,
I think we've kind of explored some of those issues simultaneously, and I think it's, again, well briefed.
Thank you, Your Honor. So, for these reasons, the Respondent Public Service Commission respectfully asks that this court grants motion to dismiss Bowman's petition for judicial review in its entirety. Thank you.
Well, and I'll just say,
Yes.
the last point, the motion to stay in your position really has no practical effect because your position is they're already out of the queue. I could grant a motion to stay, but nothing actually happens.
Yes, Your Honor. That is in substance our position. There's no status quo for Bowman to protect at this point.
All right.
Thank you, Your Honor.
All right. Thank you, Mr. Smith. Mr. Riley.
Thank you, Your Honor. I want to start by emphasizing the issue of mootness. Mootness, of course, is a threshold jurisdictional issue. And as Justice Pinson of the Georgia Supreme Court succinctly summed it up in a concurrence just over a month ago, this is in the Dean versus Georgia case. He said, quote, when the resolution of a case would be tantamount to the determination of an abstract question, not arising upon existing facts or rights as when the remedy sought in litigation no longer benefits the party seeking it, then the case is moot and must be dismissed. Just so here. Close quote. That's the Dean versus Georgia case, 2025 Westlaw 1507453. And of course, it's not a new principle. This case relates to specific interconnection costs, specific dollar amounts. The November 26, 2024 order specifically required Bowman to pay those specific dollar amounts. And implicitly in so doing, found those costs reasonable. And it did conduct an extensive review, and we can talk a little bit more about the timeline of that review. But in our case, the petitioner failed to pay in post-security for the required interconnection costs as ordered by the commission and as required by the contract that Bowman voluntarily executed with Georgia Power. And as a result of its failure by the plain language of these governing documents, Bowman was withdrawn from the interconnection process and removed from the queue, and it lost its position. The specific interconnection costs that Bowman complains about in this proceeding and contends are unreasonable are no longer valid and will need to be restudied under the plain language of the governing documents. And therefore, its petition, which asks this court for a remand to the commission to review the reasonableness of those specific previously assessed costs and a stay of the commission's orders approving those costs, is moot.
Well, and I think as you point out in as your briefing of the commissions, Bowman's free to, or maybe even perhaps likely to, start the process over, get a new rate, go back before the commission.
Absolutely, Your Honor.
And so with that expectation or not a remote possibility, would you have anything to add to the mootness exception about it's capable of repetition yet evading review? We're going to be right back here on this procedural aspect of whether they were entitled to an evidentiary hearing.
Yes, it does not evade review because, as Your Honor has noted, they are perfectly capable of restarting the process if that is what they choose to do. But there are commission-approved procedures, and indeed the QFIA itself is a form contract that is approved by the commission, and it is specifically tailored to specifically studied costs for any given project. Those documents set forth the process that anybody who wants to interconnect has to follow. And so if they follow that process and they get to the point where they get interconnection costs that have been restudied based upon where the world is now, where the electric grid is now, where the interconnection queue is now, then they can challenge those costs in front of the commission. And those costs could be higher, they could be lower, we don't know. But that would be the opportunity for them to make these arguments. And if they don't prevail in front of the commission, and if they don't get a stay from the commission of its orders, then what they need to do, and what they should have done in this case, is file their petition for judicial review before this court and ask this court for a stay in order to preserve its jurisdiction and to avoid this mootness issue that is present in the current case because of the choices that Bowman made and because of the fact that it did not timely, not just ask for, but obtain a stay, if not from the commission, then from this court, to avoid the settled consequences of what happens if it chooses not to pay the interconnection costs that have been imposed. And so it doesn't evade review because they've got their opportunity to pursue their rights before the commission. And should they fail to prevail before the commission, they have their opportunity to come to this court on a petition for judicial review. And the Administrative Procedure Act, which governs here, specifically provides in OCGA 501319D1 that a petition for judicial review does not stay the effect of a commission order. And in fact, the commission's orders on their face say that a motion for reconsideration or any other motion does not stay the effect of this order. Now, what 501319D1 says is a party, an aggrieved party, may seek a stay from the commission or the reviewing court for good cause shown. But obviously, that has to be done in a timely fashion and before the thing that you are seeking to stay has already taken effect. And Bowman did not do that here in the face of plain language of the commission's orders saying, you have to pay these specific costs by this specific date. They signed the contract obligating themselves to pay the cost. They gave notice to proceed, saying, let's proceed with this project, obligating them to pay the costs. And then they didn't pay the costs. And the clear consequence of that failure to pay under their contract and under the commission approved procedures was you lose your spot. You're removed, you're withdrawn from the interconnection process. So we do not believe that this is an exception to the mootness doctrine because it is capable of repetition yet evading review. We believe that this is a poster child for the mootness doctrine because the specific costs that are at issue here and about which this whole case relates are no longer applicable. And we can talk about some of the key provisions of the contract that was approved by the commission and of the procedures that were approved by the commission that demonstrate that. So the QFIA, the contract, section 2.1, states the cost estimates and amounts stated in Exhibit A are valid until the deadline for payment stated in Exhibit A. If there is a change event, which includes a failure to pay those costs, the cost estimates and amounts stated in Exhibit A are subject to adjustment under project changes, which is section 2.7 of the contract. Section 2.7 says all estimated costs and schedule information stated in Exhibit A are for the scopes of work contemplated by the study report and as described in the factual basis portion of Exhibit A and include no allowance for a change event. So the process here is that you do have to go through a very detailed study process in order to study the feasibility of the requested interconnection to the electric grid. We're talking here about interconnected facilities, and it is a dynamic grid, and it depends on what's going on that grid at any given point in time. And so detailed study is required to assess safety and reliability and also associated costs. And that is what happened here. And as Your Honor noted, it is a time-consuming process. So they submitted their application to interconnect in April 2022. There were preliminary meetings. They then signed a study agreement saying, go ahead and study our project in December of 2022. After a year of this detailed study and analysis, Georgia Power provided the final results of the studies to them that identified the specific interconnection costs that they complain about here for their proposed project in January of 2024. Once those costs have been established by the study process, they get incorporated into the QFIA. The QFIA relates to the specific project as studied and the specific costs. And so Georgia Power provided that contract to them on March 27, 2024. So Bowman knew on March 27 of 2024 what the required interconnection costs for its proposed project were. Well over a year ago now. And
Then the commission kind of stayed the effective date of that so they could consider these other arguments. And they come out on November 26th and say, denied, and they set the time limit. You've got to sign this within 10 days.
correct. And the reason that they did that was because Bowman filed an emergency petition with the commission the day before its deadline to execute the contract and said, give me a stay of that deadline. and give me declaratory relief saying that these costs that are being assessed are not reasonable. And there was, as the Attorney General's office noted, there was full briefing, there was submission of written evidence, there was argument of counsel for the parties, and commission staff review of the studies and the supporting data, and the following recommendation that the petition should be denied. And that's what the commission did in its November 26th order.
I'm just trying to clarify, because I think I got Mr. Smith to mention this, and I think you've alluded to it too, which is your position is if they had not signed the contract and they came and filed this petition within that 10-day deadline to sign it, perhaps got the stay, perhaps not, but preserved the issue through a petition for review, a court would have the power to say that November 26th order was an error. You got to go back to the drawing board, maybe give them a new quote, and then you have to have an evidentiary hearing, assuming that that's actually procedural error. Is that a scenario that is lawful?
I think that is at least possible, Your Honor. I mean, I think that if they wanted to press their argument that an evidentiary hearing was required, and we do not believe that it was, and the commission has rules for petitions for declaratory relief, which is what Bowman filed here in front of the commission, that do not require a hearing, that put that question in the discretion of the commission. But that's a separate issue. But if they wanted to preserve that argument, and again, ask the commission for a review of the reasonableness of the specifically assessed interconnection costs, they needed to do that before they were removed from the interconnection process and before they were removed from the queue. And there was every opportunity for them to do that under 501319D. They had other options. They note in their supporting evidence in their motion to stay, well, they didn't want to walk away from their $600,000, $700,000 investment, whatever it was. Okay, fair enough. They didn't want to walk away from it. They could have paid the costs and challenged them. Now they say they couldn't have paid. They didn't have the money. They couldn't find the investors. Well, credit that testimony. What else could they have done? What they could have done is engaged in the procedural mechanisms that were available to them to obtain a stay, not just ask for a stay, but obtain a stay during the relevant time period before the commission's order became effective and removed them from the process. And again, talked a little bit about the contract provisions, and this is a contract that Bowman signed after the commission's November 26, 2024 order. They said they faced a difficult decision and they made a difficult business decision. Well, they made their bed and now they have to follow the rules. They have to do what the contract requires them to do, or get somebody with jurisdiction, either the commission or this court, to tell them they don't have to do that in order to preserve the issue of interconnecting for this project under this study, under these costs. And this is also, these principles are also reflected in the interconnection procedures, which are incorporated into the QFIA. The commission held a process in this docket under its jurisdiction to regulate these interconnection issues and costs, and said, what are going to be the rules of the road here? And they adopted interconnection procedures, which talk about the interconnection queue and position, and they define interconnection queue position as the order of a valid QF interconnection request relative to all other pending valid interconnection requests. And it states in a couple of different provisions that if the agreements are not executed within the required timeframes, quote, the QF interconnection request will be deemed withdrawn and the QF's interconnection queue position will be terminated, close quote. Likewise, there is a interconnection study process that's incorporated into those procedures that states in section 3.6, withdrawal will result in the loss of interconnection queue position. So the argument that Bowman has made to this court that, well, there's nothing in the record that shows that we've actually been removed from the queue is simply not correct. The approved procedures, commission-approved procedures, the terms of their contract all say, this is what happens if you don't make the payment, the timely payment of the interconnection costs and post the security. This is what happens if you are deemed withdrawn from the process, which is what the November 26, 2024 order did. And Bowman knows this. Bowman's own admissions show that they understood that if that November 26, 2024 order wasn't stayed, their facility would be removed from the interconnection queue. That's at paragraph 12 of Mr. Anderson's affidavit filed in support of their motion for the stay in front of the commission. Indeed, in their petition here at page 24, they say that if they don't get the stay, that Bowman's QFIA will terminate and the facility will be removed from the company's interconnection queue. So the consequences of their conduct were clear, and what they failed to do was to obtain the requisite relief to preserve the issue, the reasonableness of these costs before it was too late. So, you know, there is heavy reliance, Your Honor, from Bowman on this Green Bowl case. Green Bowl is totally distinguishable and not applicable to this matter. It involved a foreclosure sale, and in that case, the trial court denied a request to enjoin the foreclosure sale, but then granted an injunction pending an appeal, which it has the authority to do. And what the Green Bowl court said is there was nothing improper about, there was no abuse of the discretion of the trial court by granting an injunction pending an appeal, because the foreclosure moving forward would moot the appeal. The petitioner or the appellant in Green Bowl sought and obtained stay relief from the trial court. Here, the PSC denied Bowman's request for a stay, and Bowman's petition for judicial review has been mooted because they failed to pay the required costs, resulting in their removal from the interconnection process and queue, and those costs are no longer valid or relevant. They had a specific deadline. They were based upon a specific study with specific timelines, and all of that has now changed. The world has moved on. We can't simply put Humpty Dumpty back together again, and jamming them back into the queue would be contrary to the approved procedures and their own contract. It would hurt Georgia Power and all of the other entities out there that are seeking to interconnect, who are following the rules. And it wouldn't serve the public interest by rewarding somebody for not taking the necessary steps to pursue their request to interconnect. And if Bowman wishes to proceed with interconnection, it absolutely has every opportunity to do that. The costs have to be restudied because that's what the governing documents say, but that avenue is available to them. But the point is that the costs as assessed and as incorporated into the contract and as ordered by the commission to be paid by a date certain were not, and there were consequences to that. And those costs are no longer valid. They've got to be restudied, both under the terms of the governing documents and also based on the reality that the electric grid isn't static and that there are other people in the queue. So that is the basis for the mootness argument that we make here, Your Honor. And the same thing applies to the request for stay. One cannot obtain a stay of that which has already happened. And we could talk more about the stay request if Your Honor likes, and our position that even absent the mootness, they have not established the requirements for a stay here. But I don't think it's necessary to do that, and I'm happy to do that in response to argument for Bowman, if that is the more efficient way to proceed.
All right, thank you, Mr. Riley.
Thank you, Your Honor.
Good morning, Your Honor. Newton Galloway and David Penland on behalf of RGP Bowman Solar. I've already introduced Mr. Anderson. If I could get the court's permission, we do have a brief handout that I will refer to, and if Mr. Penland could help distribute that, we have copies for all of it. Let me wait for him to get those distributed because I will be using them in the argument. Get one. It is very easy to discuss this project in the academic terms of interconnection, but I also think it's important for you to see what we're actually talking about. So if you look at the handout, the very first section is the Q public record on the Bowman property. This is located in Elbert County, and it consists of 372 acres. This is a standard solar type tract where solar is proposed as a new land use on what has been previously and historically used as farmland. 372 acres is enough to support an 80 megawatt project. It is not enough to support the large utility scale projects that are approved by the Commission in Georgia Power's RFP process. And those are approved through a process called the Integrated Resources Plan, which we have just almost completed for 2025. Now, the reason being is you have to have roughly 10 acres to have a megawatt. And that takes a lot of land. And one thing I have learned in doing energy work at the Commission is that there is no such thing as a perfect generation resource. We talk about solar being clean, and it is, but it takes up huge farmland tracts. And there are a lot of people, because the other side of our practice is zoning. There are a lot of people in South Georgia who don't like that. If you turn to the next page, what makes this unique is that the Bowman project is located north of I-20 and just south of I-85. I would have ordinarily thought this project would have been received favorably, even if it's a QF, by Georgia Power, because there is a dearth of utility scale generation located north of I-20. And in fact, one of the problems that the state has is that the thing we learned first when the first solar RFPs were introduced in 2013, after the 2013 IRP, was that the key in developing projects is cheap land in South Georgia. So now we have all of these huge generation projects in South Georgia, and we've got to figure a way to transmit that energy up to North Atlanta. So the location of this is unique, and it is recognizing how Georgia Power feels about QFs. When I was first approached by Mr. Anderson, I thought we had some shot of having this walk through easier because of its location, but that did not occur. One comment before I get into mootness on interconnection generally. All utility interconnection disputes, I don't care whether it's telecom or whether it is electricity. They are tied to two key points. The first is that the incumbent regulated carrier is being asked to interconnect to provide a service to the interconnector. And the question there is, what's the cost? Are they being overcharged? And tied into that, the second component is non-discrimination. If the incumbent utility is being asked to interconnect the policy should make certain that interconnector number 1 doesn't get a better deal than interconnector number 2. So when we make a request for hearing, that was the context that is applied here. That's the context in which it was raised. Are the prices reasonable? And is Bowman being treated the same way as everybody else? This is the first case involving interconnection issues before the commission for a utility scale solar project. This is the first interconnection case, to my knowledge, where any Georgia Power interconnection facility has been challenged. Now, let's go to mootness. We're all educated. We're all, the Georgia Power team of lawyers are always excellent. And we understand that mootness occurs when there is no possible way under any legal theory or any factual application that Bowman has a remedy. I don't think there's any dispute in that. And I would like to quote from Georgia Power's brief, page 10. They make the following comment. Indeed, no matter the outcome of the requested hearing or the determination of the reasonableness of the assessed interconnection costs, the interconnection process about which Bowman complains has been terminated and cannot be resurrected. We disagree. We disagree on both. There are only 2 documents that the court needs to assess mootness. The first is the commission's hearing, what I refer to as the hearing denial order. That is the order of November 26, 2024, which is the next document in the handout. And it is here at the bottom of page 3 where we have highlighted. This is where the commission makes its determination. And I've highlighted the applicable section. The company's QF interconnection studies of the Bowman project were completed in accordance with the qualifying facilities transmission generator interconnection procedures. And then drop down a sentence. The study reports identified interconnection upgrades as either interconnection facilities, network upgrades, or affected system interconnection utility upgrades. Those are definitions that are found within the procedure document itself, which was drafted by Georgia Power but approved by the commission. Staff has completed a desk review of the company's interconnection studies and the associated costs of the identified for interconnection upgrades. Well, I want to talk for a second about desk review. That is a term that is foreign to me. I do not know what it meant, what it means. There is no definite definition of that in any procedure. And there is no report on exactly what was done and who was there. Now, let's be candid about how the PSC works. Mr. Hewitson, who is Georgia Power's lawyer in front of the commission, and who does an excellent job. Mr. Hewitson and I deal ultimately in an environment that, yes, while it is administrative law, it's a political environment. And as a matter of practice and as a matter of courtesy to the commission, when an issue like Bowman comes up, we attempt to advise the commissioners about what the issue will involve and go through that informally because there is no ex parte rule that prohibits it. And that is simply an introduction to say you're going to be facing this down the road. At that point, you then file the petition. You ask for review. Now, we ask for a procedural and scheduling order to schedule a hearing because that's what the commission has done in all other interconnection agreements or interconnection cases in which it's been involved, principally telecom. Interconnection is not a foreign concept to the commission. But in telecom, we issued a PSO, they issued a PSO, we complied with the PSO, and they conducted a hearing. Now, I will state in my place that that's not the only way this could be done efficiently or accurately or responsibly. There could be a different process used, but that's what the commission has done before. That's the reason we made the request. I have no idea what a desk review is. And I might add, I have a little hesitancy because we work with the staff every day. I have great respect for the commission staff, but I don't know what that is. And I can assure the court, we were not asked to bring documents to put on a desk.
Well, let me ask you on that point. Apparently there was a good amount of briefing that led up to this order. Apparently affidavits submitted, the reasonableness, kind of gone into in those briefs. Is there something that you had not already made part of the record, as it were, as part of your briefing, that you contend would have come up at an actual evidentiary hearing?
Yes, sir.
All right. And what kind of things?
If you look at the interconnection study, there are two interconnection studies, and you're going to learn that you go through several studies. The interconnection process is long, and the interconnection study process is expensive. Ultimately, the interconnection study process goes now under the state jurisdictional QFIA process, goes through two studies, and it takes 6 to 8 months. There was an error in the way the system was working that had to be corrected on Bowman, so he went through the first phase twice. Then you go through phase 2. Now, they tell you what is required. For example, if you look at phase 2 interconnection study, you will see that Bowman's required to rebuild from scratch about 34 miles of either 115 kV or 230 kV lines at a cost of $68 million. It does not tell you what the components of that would require, nor does that study tell you how the cost estimate was reached. So if you went into a hearing, you would be able to challenge potentially. And when I say challenge, let's caution, another word of caution here. At the commission, even if we go into an interconnection proceeding, I have no discovery. And you have to find ways to challenge that determination outside of what the court would recognize as a standard discovery process. The staff would, but no intervenor or no petitioner at the commission can direct the staff to conduct discovery. So those issues would be there, and you should be able to come forward and present technological evidence to say this isn't correct. This is overpriced. We attempted to do that by bringing up in support of the petition testimony from Mr. Howard Smith, Mr. John Kelly, who were former network transmission executives with Southern affiliate companies. They worked all over. Let's just say they're Southern affiliate companies. And there's not one reference to that testimony. Now, that testimony was not discussed directly with staff during a desk review. We did introduce them as experts that we would rely on to the commissioners during the walk-around introduction meetings.
And the affidavits you submitted raised many of these concerns and
That's
why
correct.
you think the cost should have been much
That's
lower.
correct.
But I certainly grant you that having to have the other side justify their costs and you being allowed to challenge them on that could create a whole host of new arguments and evidence for them to consider. But I wonder, can you really so confidently say they did not do any kind of review of the reasonableness here? I mean, I understand that desk review is not really a legal term of art, but if you strike the word desk and just say review, it says they reviewed the associated costs. Maybe they didn't review it in the level of detail you wanted to, or with all the evidence that could have been brought forward. But I don't know if it's an unreasonable construction to say a desk review is just a review of what I'm doing right now at a desk.
And Judge, I don't know either. I have no way to know what that constituted. We have no guidance in commission rules or orders that say this is appropriate for the review. I have no idea who was involved with the discussion. We were not able to come in and present a desk review. But to get back to your question, is there a finding of reasonableness? I read this, and when it came out, the way I looked at it, they were saying essentially, okay, you've complied with the procedures to study. Okay, and that's it. Now, do we draw the conclusion from that, as I put in the brief, therefore, if you've complied with the procedures, it is therefore reasonable? Well, complying with the procedures and actually finding costs are two different things. So from my perspective, there is no finding of reasonableness of those costs. I don't see it.
So your position would be if they comply with all of the procedures cited in here, that does not imply or guarantee a reasonableness?
It doesn't mean it's accurate. Now, I want to isolate the QFIAs first, because those issues are, in our opinion, easier to deal with because they are secondary. The QFIA issues are secondary to this order. There are two QFIAs, and we can't lose track of that. The first is March 27th, 24, which is what prompted the first petition asking for a review of reasonableness. And by the way, one other point on the size and reasonableness of these costs, this is the largest amount that I have ever seen in a QF interconnection study agreement by more than $20 million.
But even if, I mean, this is kind of not completely germane to what we're doing here today, but if you've had your hearing, you introduced your evidence, you're allowed to cross-examine their evidence. If it comes out to the same finding, comes back to me, I'm applying any evidence standard.
That's correct.
So it's
We've
an
lost.
uphill battle,
Correct.
regardless of what happens here.
That's correct.
Can we?
And I might add, we have never suggested that we wanted anything other than some form of a hearing for that very reason. We do not know, and there is not enough information in the study agreements. I'm sorry, not the study agreements, the interconnection studies. We cannot say, and I cannot represent to the court, that there would not be a mechanism by which the company would be able to come and show reasonableness. Just like they cannot assume that we could not show reasonableness. And we have never suggested to the commission, you need to reduce it internally just on your own. It can't be done. It is appropriate for this to be the process or be analyzed in the process of a standard proceeding to review the data.
Correct me on this. After this November order, didn't the amount due, didn't it increase?
It increased by about, I want to say about $1 million, I believe.
Did that have anything to do with what they considered interconnectedness costs or some other things? And if it increased, doesn't that imply that they actually did look at the costs? It's in the, I can't really answer that right now. I've got the QFIA with me. I've got both QFIAs with me. But here's what happened. There are portions of costs that Bowman didn't dispute. For example, they've got to do a substation where it interconnects into, I believe that is a GTC system, isn't it, Neville? All right. And that nobody's disputed that. That's an $8 million charge. There are also costs related to tax impacts, and there are also costs related to other things that are not tied to the specific network upgrades. And if I recall correctly, the changes related
to the non-network upgrade provisions, as best I can recall. Now, as they say at the commission, that's subject to check, and it depends on the accuracy of my memory. But if I can go back to the QFI.
Wait, I'm sorry, in your best you can recall at this point, the reason for the $1 million increase is attributed to what?
Non-network
Non-network
upgrades.
upgrades. Okay. And if with your indulgence, I'll just check in with opposing counsel. Do you have anything else that you would say on that point?
Your Honor, just, to the question of did the commission review and make changes to the QFIA? The answer to that is quite clearly yes, based on the plain language.
Just focusing solely on the money. Why did the money cost go up? Do you have any idea offhand?
Well, paragraph 1 of the commission's November 26, 2024 order says that Georgia Power will revise the draft QFIA for the project to reclassify the GPC upgrade, names it, as refundable network upgrades. So some of these costs that are being paid or security posted by Bowman ultimately get refunded back to Bowman because they are classified as refundable network upgrades. And so that is my understanding of the nature of the modification that was made from the QFIA as initially presented and the QFIA as ordered to be revised by the commission. I cannot speak specifically to was there a dollar amount change, but that's the change that is clear from the face of the commission's November 26, 24 order.
Go ahead, Mr. Galloway.
If I recall, the bulk of it, Judge, if you look on down to D, the bulk was tied to the
Letter of credit.
1.1 tax,
Yeah.
I think. And if.
All right.
like I
Well,
said-
the core of this argument, what's before us today is this mootness. And so I'm having a hard time getting around the fact that in this argument that your opposing counsel make, that you had this order, you did not like the results of it, but you signed the contract anyway.
All right, I'm going to address that. And that's exactly where I was going with the two QFIAs. You got to understand the timeline here. Georgia Power sends a QFIA on March 27th, 2024. All right, that's the first one. That was challenged by the first petition at the PSC on April 26th. We're given 30 days to sign. All right. That becomes the basis for the entire petition, asking for the hearing to determine whether the interconnection costs are unreasonable. Now, we go through the process that we went through, and these multiple briefs that are filed are tied largely to the legal issue of whether the hearings require. All right. So we get to November, and you need to understand, I think Mr. Smith suggested that there have been hearings on this. No. What happens is an agenda item is placed on the Energy Committee for review before it goes on an admin session agenda where it is approved. So Mr. Hewitson and I are standing up there making an oral argument, which is informal. It's not part of a hearing. It's not part of it. It's just the way the commission works. All right. So on November 26th, the commission issues the order that you have in front of you. Now, we've been criticized for how we've handled after this order comes out. And they read to you portions of Mr. Anderson's affidavit. Mr. Anderson understood, we might not have agreed with it, but Mr. Anderson understood what the commission was telling him to do. All right. That's not in dispute. All right. But that doesn't mean this order. It doesn't mean that this order is appropriate. It doesn't mean that it is sustainable. Now, so this becomes, if you will look at the highlighted sections in yellow, this becomes the second QFIA. Now, if you will look at, in terms of why we signed this, the last 3 pages of the handout, you will see what happened on the first one. What you have are 3 emails from Ms. Chen. Ms. Chen works with Interconnection in Southern Company, and she's the person who coordinated the execution of the QFIA. Now, the first QFIA is conveyed to Mr. Bowman, Mr. Anderson on March 27th of 24, and it says, execute this agreement and provide notice to proceed on or before April 27th. She provides him with a supplemental email on April 22nd. On April 26th, we filed this petition. And on April the 27th, after we had filed the petition at the PSC, he gets a notice that the QFIA has expired and been voided because the envelope has expired. And therefore, Georgia Power contended that and challenged the non-execution of it. Now, here you had in the November 26th order, you have clear direction. I call this the 5-point to-do list, where the commission sets out 5 particular things that have to be done. And failure to comply with any of those gets it kicked out. That does not mean this order is legal or justifiable. It means they ordered it. And that's what the challenge is up here to ultimately today if we get to a substantive challenge. Now, we already, in response to this, we filed a motion for reconsideration. And of course, yes, that can't stay on its own. We had asked for extensions of time to the commission to allow these things to go through. That was never approved. So as a result, and I will tell you, I worked with Mr. Bowman, with Mr. Anderson. I'm sorry, Neville. I worked with Mr. Anderson in that month in an effort to try to save the project to find funding. And at this level, and with the requirement of security being posted for years at the amount of $76 million, because you don't get it back until, we think you don't get it back until COD, you might be interested in knowing that the commission has no guidelines for how the security will be held.
I think you talk about it in the briefing. And offhand, the 10-day deadline to sign, the 30 days, I think, back in April 2024, are those things that are just custom and practice? Are those set by regulation or rules?
Not set by regulation. They're set by the pro forma contracts that the commission has approved for QF interconnection. The commission approves all RFP solicitation program contracts in a pro forma form. These contracts are never filed at the commission. The form's there, but this interconnection agreement never comes back.
Just the point being is this kind of the tight deadline is just something that's solely proposed by Georgia Power, and is that unique to this case, or is that kind of how they've handled that? How so?
The 10 days, if you look at it from the date of the order, Bowman had until 10 days of receipt to execute the new QFIA. Usually it's 30. Bowman had to execute the notice to proceed the next day after executing the QFIA. Usually that's 10 days after the QFIA comes in. And I want to talk about the impact of that. We're progressing.
Well, I mean, I think you described it in your briefing that it's just, and I don't think that could even be really argued, that it is incredibly hard to come up with financing for $76 million in 30 days. So I take that point.
You're
and
absolutely
so,
correct.
but the argument is that that from the outset, you get this order and you realize we've got 30 days to do that. Then you have to just make that, and it's not an easy one, but a calculation of, do we take the risk we can do it? Or do we just immediately try to say this order is procedurally improper, so let's challenge it?
Well,
And
we
you made a choice.
had already challenged the procedure asking for a motion for recon. Now, we did not expect that to be approved. But I want to talk about how how this order changes the QFIA, because there's more to it than that. If you'll look at the handout dealing with the interconnection section, you'll see the requisite provisions of section 2.7 and 4.5 of the QFIA. And these would ordinarily govern the procedures of the parties, but for this order. Termination is covered in 4.5. In the event of a change event, either party may terminate by giving 60 days written notice. So that went away. Understand that went away because Georgia Power says you got terminated by the order, not the QFIA. Under 2.7b, a change event occurs when a generator fails to make a timely payment of any sum or does not post security. All right. Excuse me. So once he was not able to post security, the QFIA would kick in for 4.5, which says you get a 60-day notice. But if you look at the order, this supersedes the company's position, the commission's position is that this supersedes anything in the QFIA that was signed. The same is true for the Q, because you will look at section 5 on the to-do list. Failure to provide the cash payment and letters of credit as required above will result in the Bowman project being deemed withdrawn from the process. So the withdrawal from the queue is done by commission order. By the way, we double checked while you were asking questions earlier. When Bowman requested interconnection, it was assigned a QF interconnection number. It's identified in the pleadings as QF 1034. At that point, they were assigned a position in the queue as of mid or spring of 2022. Now, so by doing the order, Georgia Power was able to shut down Bowman by December 26, 24 and not comply with the terms of the QFIA. Now, but there's one thing that they did not discuss that I think is crucial. The QFIA in November, the new one in December, is tied to one document, and that is the commission's order on November 26. If the commission's order on that date is not upheld or affirmed by this court, the QFIA that Mr. Anderson executed is null because they did not have the authority to send it to him. Now, the QFIA depends upon the hearing denial order, and that presumes that the hearing denial order is valid and legal. It presumes the hearing denial order is not arbitrary and capricious. It presumes that it is supported by the law. It presumes that the desk review was appropriate. It presumes that the interconnection costs themselves are reasonable. And if that is the case, the only QFIA that's really pending before you is the one from March, the one that was sent in March. If the hearing denial order of 1126 violates OCGA 5013-19H 1 through 6 or any of them, it is void. It is a nullity. It cannot support the to-do list, and that means the requirements here are essentially useless. And it means that the challenge to the QFIA that issued on March 27th, 24 has not been terminated. And Bowman's project, in our view, is still in the queue. Now, you could look at it another way because you could say, well, he executed this QFIA in December. Well, let's assume that is separate from this order. At that point, they don't get to rely on the order to get this terminated early. And this goes, they've got a 60-day notice period, which we've never received, and nobody has said that it was received. Now, my personal belief is that this was done this way in order to get Bowman shut down before the end of the year. And to avoid having to, the company could rely on the commission's order to remove Bowman from the queue without having to come and justify a basis for its removal after it had occurred. Now, I do not know what else could have been done really to preserve Bowman's rights pending appeal. He received a QFIA and we challenged it. We filed a petition that was denied. We filed a recon to challenge that. That was denied, along with a motion for stay. That was denied. And then we filed the petition to Superior Court and asked for a stay up here. And with all due respect to the company's counsel, we think that Green Bull is directly on point because it distinguishes between the risk of the stay versus success on the merits. And it notes exactly what Georgia Power is arguing here, what the commission is arguing here. And I might add that the motion for stay, the denial of a motion for stay, can be just as arbitrary as the denial of a motion for hearing. Y'all have great discretion. The commission has great discretion on a stay, but it can still be arbitrary. So therefore, you have our request for stay up here. Excuse me.
I mean, but to their point earlier, I mean, is there really anything that practically changes whether the stay is granted or not? They're either gonna, they say you're out of the queue. I mean, there is nothing physically that says you're in line in a queue, and we can say you're in, we can say you're out. I mean, what actually would change as a result of a stay? I mean, you either succeed on this petition or you don't.
It preserves where the parties were as of the time the QFIA was provided to Bowman.
Okay, the parties
If you-
being, there's a contract that's still
It's
at
still
play under
subject,
these
it's
same
still
terms.
subject to dispute before the commission and well, not before the commission, but certainly before this court. Now let's talk about what happens if you go back and refile, you reapply. Okay. I will hazard the guess that the cost will increase further. And I will also hazard the guess that excuse me, I lost my train of thought. Oh, you will have, well, this isn't hazarding a guess. He would have to go through that interconnection process again. And that cost is between $100,000 to $200,000. He has property under lease to provide and do this project. He has zoning approval in both Lincoln and Elbert. Is it Lincoln and Elbert counties? Hart County and Elbert. Particularly with the environment we face in zoning hearings on behalf of solar, I can't say for certain that a political change could not occur that attempts to remove that now.
So he's currently zoned indefinitely, which allows him to build that.
Correct. That's correct.
And would you say you have like a vested property right at this point based on what you've already done?
He has the right to build his solar facility at this location.
But I understand your point. All right.
So it's not as simple. Yes, you can go back and refile. We would acknowledge that. Yeah, you can go file again. And like I say, those are the things that we see immediately. So I will conclude. I will say that QFs, I want to conclude by saying QFs were not viable in Georgia for years. And the reason they weren't viable is because the cost of solar generation was so high, and the fact that the QF under PURP is required to generate at avoided cost. Now, I'll put those in terms, real terms. In 2008, when our law firm became first engaged in solar, the cost of solar generation was probably 25 to 30 cents per kilowatt. Avoided cost was 5. Solar declined in price. And certainly there's some economic government incentives in there that may go away with the big, beautiful bill. But solar declined in price separate from that. And it became clear that they can generate and they feel they can make money at a true avoided cost. So it became a viable generation option in 2019, roughly 2019. Now, again, I would have expected the company to have a more favorable view of them now because they need the generation. But that has not been the case. And as you can tell from the record that the commission sent up to you, we were involved with both the Heelstone docket that is identified as part of the record and also a Pine Gate petition that's very comparable. And we were thankfully able to get those resolved. But I will tell you, when I saw $76 million, I knew what was coming. We would ask the court grant the stay for us so we can at least try to maintain and get to argue the merits of the petition and deny the motions on mootness. Thank you, Judge.
Thank you, Mr. Galloway. All right, well, I'll say just a few remarks for the parties on the case from here. I'll concede from the outset that I've yet to have a Public Service Commission case. I think it's well briefed, well argued by counsel. This is one of the more complicated administrative issues I've ever had to dive into. And so there's plenty for me to review here and to dig in and try to reach the best result that I can. I will throw out there, if just in the nature of kind of reaching the best result, I couldn't convince Judge Eaton to take this case from me with some subject matter expertise. But if the parties would prefer at any point and come to an agreement on a special master under Rule 46, I'm happy to consider a report and recommendation. I actually mean that sincerely because I know this is such a technicalized and specialized area of the law. But if I don't hear from you, I will be making that call here myself. And so, again, I'll just say for guidance that I'm going to review the arguments and again, the case law presented because of the extensive kind of procedural history. I'll likely be asking for a proposed order that I'll then work with. So I would expect that request to come by email in the next, probably no later than the end of this month, but maybe sooner than that as I work through these issues. And
Your Honor,
yes, sir.
I'm sorry, I don't mean to interrupt.
Not at all.
I wanted to ask, would it be appropriate for me to just offer one comment in rebuttal to opposing counsel's argument? Because it goes to the question of, are these timeframes and timelines unique? I can do that with Your Honor's permission, or we can address it in the.
It's your burden on this motion, I believe, so you'd be entitled to the last word. So if you just want to address that one point, feel free. And
Very
Mr.
briefly.
Galloway, if you want to respond to it as well, you can.
This is not unique. The timeframes here are set forth in the commission-approved TGIP interconnection procedures. And those were approved by the commission in an order in May of 2022, and neither Bowman nor anybody else appealed that order. And in section 11 of those interconnection procedures, which are incorporated into the QFIA that they executed, it says after receipt of the draft, generator will have 30 calendar days to execute and return. After the QFIA is signed by the parties, the interconnection will proceed under the QFIA terms and conditions. If the generator does not execute and return the QFIA within 30 days of receipt, the QF interconnection request will be deemed withdrawn. Same language that's in the commission's order.
That's from the commission's order from, was that the 2021 or is that even earlier than that?
What I'm reading from here is from the interconnection procedures. These were approved by the commission in a 2021 order, which is at tab Q of the record before you. And they were posted by Georgia Power on its website pursuant to that order as reflected in tab R of this record. So
So your point is that these deadlines are not really a discretionary act of Georgia Power. They're imposed by the commission's
correct,
regulations.
and set pursuant to established and approved procedures.
All right.
Thank you.
Mr. Galloway, any point you want to make in response?
QFIA procedures were approved. We've challenged some of those QFIA procedures or the qualifying facilities transmission generator interconnection procedures, TGIP. We've challenged those. Never been addressed. There's no dispute that at some point, if you don't pay the cost, you get out of the queue. Now, you can read the contract as we did just a minute ago, and it says, okay, it terminates. After they have to give a notice to terminate. At the same time, what Mr. Riley has said, and I haven't checked it, Tom, but I suspected, I mean, he hadn't misrepresented what it says. Again, we know a project comes out of the queue if costs aren't paid. That's it. And if that had occurred and without a challenge, Bowman's not up here. They've lost the right to be here. That's all.
And my point into going down that avenue was how it might relate to any of the mootness issues. I would agree with you that 30 days is a pretty tight deadline to come up with financing for 76 million if you hadn't anticipated that. Although, I recognize that you might have seen this coming down the pipes. But if it came up in March and then you're challenging it from that point, right? So, right. And so again, I think that might play into the mootness doctrine that we've talked about. But on that point, if there's with that point rather, is there anything else that needs to be addressed for the record on behalf? Let me go. I'll go in order here. Mr. Smith,
No, Your Honor.
Mr. Riley, or Mr. Galloway. Thank you all for being here this morning. Happy 4th to you all. We'll be off the record.
Thank you, Your Honor.
Have a good 4th.
All right.
I see Investigator Williams in the back row. Come on.